today is going to be a great program. I'm so excited that you scheduled this in your calendar to join in on talking about expert depositions. One of my favorite things in litigating personal injury cases is working with experts in all aspects in general. But there's nothing more intellectually stimulating, challenging, just interesting, fun than taking the deposition of an expert when you've prepared properly and executed it properly. Yeah, it makes you feel really good to be a lawyer, and I'm happy to talk about it today. So, it was funny. I got a Dennis Carrion, who's a member of the group of all of us who participates in a lot of these CLEs. He reached out to me. He's like, "Did I miss something? Are expert depositions happening in state court now?" No, Dennis, you didn't miss anything. Still in New York State, it is very rare to do a deposition of an expert. You have to seek leave from a court to do so. However, federal court, it is commonplace. There's always in the scheduling order in federal court, time to exchange expert reports, a deadline to conduct expert depositions. So if you ever find yourself in federal court, you're going to want to be ready and prepared to handle expert depositions. Also, many other states outside of New York have expert discovery. I'm handling a matter right now in Connecticut, and in Connecticut state court, I think they call it Superior Court, the experts are questioned as part of the litigation process. So even if you don't think that you're going to be questioning many experts as part of your practice, the strategies that I plan on discussing with you today can apply for when you're preparing for cross-examination at trial. If you handle any medical malpractice or product liability cases, you're always going to be dealing with experts in those. So in medical malpractice, it's going to be expert physicians you're going to have to question. So I think that there's a lot to learn in this area, and I think there's a lot of tips that I'm excited to share with you that maybe you haven't availed yourself of. As I always say in my CLE, in any CLEs when I attend them, if you just pick up a couple things, that help out, then it's worth it, right? If it makes a difference in your case. And I think you're going to find some things today that are going to make a difference in some cases that you have. Well, that's my hope. So let's get into it. Preparing for a deposition of an expert is very different than preparing for a deposition of a lay witness. So if you handle mostly auto accident cases in New York State, you're probably not questioning an expert. You're questioning a driver of a car, a motorcycle, a bus, a truck. And a lay person is different than an expert in that they're just, they don't know their way around a courthouse. They're not used to being questioned. They're going to be much more nervous. They're probably not going to fight you as hard. An expert, on the other hand, is someone who's paid knowing that they're going to be questioned by a lawyer, either at a deposition or at trial. They come into it knowing that. One of the things I like to do when I try cases and I'm cross-examining an expert witness that my adversary calls, and I start talking about all their prior testimony and all the money they make testifying and all of that. And they do it all for defense because I'm on the plaintiff side. And, I say, you've probably spent more time in a courtroom than I have. And I'm actually a trial lawyer and you're not. So you really need to be prepared, because when you're questioning an expert witness, they're going to be adversarial. You're going to be challenging them on their opinions in the case. They're going to want to back it up. They're not going to give you easy answers. They're not going to concede things easily. Experts will be defensive. They'll think they know more than you do, which they may in general, but they may not on a specific area that you're going to question them on. And we'll talk about that. Just because someone's a toxicologist, you may have a subject matter in your case that you know better than they do. You've read more. Maybe they'd focus in another area. Just because someone's a physician, their area of practice may not be in the specific issue that you've studied so hard that you're going to question them. So they will know how to answer tough questions. They'll know how to sort of bob and weave and be evasive. It's very challenging. And the way that you can have success is by preparation. If you've listened to any of my CLEs, you know my mantra: preparation, preparation, preparation. And never is it more important. It's important in everything we do as trial attorneys at every phase. But when you're preparing to question an expert in a subject matter, you need to be prepared. Okay. And this is Preparation is probably 95 to 99% of conducting a successful deposition of an expert witness. It's all the advanced work that you're doing, not as much how you ask a question. And today we're going to talk probably 95% of the time on preparation. And then with the remaining time, we're going to talk about the actual conducting it, whether you're defending an expert or whether you're questioning an expert. And what I like to do, many of you know, is save the Q&A until after the 2 o'clock hour. So from 2 to 2:30. I'll try and get through every single person's question. So please go ahead, drop all your questions in the Q&A. If someone else thinks they have a comment or an answer to a question posted, drop it in there too. I love the community that we've been building through these series and helping each other out. I don't profess to know everything by any means. I just share what I know and hope that it'll help you a little bit, okay? So sometimes you'll get a disclosure. And in federal court, you're going to get an expert report. You're going to get the report where they spell out what they reviewed. You're going to get the file that they have. You're going to see what they relied upon in forming their opinions, all of these things. And it's important that as a first step that you read through it, because sometimes first read of an expert's report or disclosure. In New York, we have 3101 D1 disclosures where the lawyer types up the subject matter and what they expect the expert to say. And a lot of times it'll come in and the report reads really strong and you're like, uh-oh, this person looks like they're gonna really hurt us. They're saying this, they're saying that. And then when you get into the deposition and you start doing your homework and your preparation, you realize, wait a second, this is nonsense they're saying in their report. I'm totally gonna, take them out at the knees when I confront them with the references and the things that I've learned to prepare for it. So one example I just want to share with that is I'm currently involved in a case where my client is paralyzed and we had him evaluated by a vocational expert amongst other experts to talk about his inability to obtain work due to his being paralyzed. And the defense disclosed their vocational expert, and her report read really great. It said that he can get a job doing this, he can do that, all the things that she opines he can do, and disagreeing with my expert. And then when I questioned her, she was basically a novice, and you could tell she didn't have much experience. I asked her if she's ever evaluated a paralyzed person before. She said no. I said, can you identify one job that my paralyzed client can get right now? No. So, when you prepare and you're not afraid to challenge the expert because you have a high level of preparation, that's when you're going to be able to speak to your adversary and say, yeah, their report's nothing. I'm not concerned about them at trial. They couldn't answer these questions. So that's one of the things you want to accomplish when you question an expert. I like to think of it as a boxing analogy. Think of it that you're going to enter a boxing ring, and that's going to be the deposition. And in one corner, your adversary is the expert. That's who you're going to be fighting in the boxing match. It's the adverse expert. And would you show up to a boxing match where the expert is a seasoned boxer, boxes people all the time, figures no problem, Smiley's new to this, I can take him out, I'm questioned more than he probably questions people. This is my wheelhouse, I'm going to be good, I'm going to take him out. And if you show up and all you've done is maybe prepare a day in advance and you're not fit, you're not ready for the fight, you get in there, you're going to get your butt kicked. But what if you start preparing a few weeks earlier or a few months earlier? You start researching this expert, seeing the weaknesses, seeing prior fights this expert's had, reading prior opinions, precluding that expert, finding out weaknesses in areas that you can attack and bob and weave. Then you show up and the expert's going to be overly confident. Hey, I can take Smiley. I do this all the time. But then you show up, you've been training, you've been prepared, you've been watching the videos, and you kick his butt. And that's what you want to do. And the way that you do that is to do your homework and to prepare and leave yourself time. You never want to prepare for an expert deposition, a day before, even 2 days before. As you'll see, what we're going to go through takes time. So when you know it's coming down the pike, the minute you get a disclosure, the minute you get a report of an adverse expert, get to preparing, because that deposition is going to get scheduled and you're going to want to be able to take him or her down. All right. Now, the very first thing I like to do is really go through the report that I receive from that expert or the disclosure that I receive. I'll read through it. I'll make notes on it. I'll make highlights. We all use computers now, which is just great. And in depositions, I've been doing all my depositions by Zoom, just like this. And I'll pull up the PDF version of the expert's report or disclosure. I'll highlight things. I'll do those little comment bubbles and annotate. Just break it down. Read everything. You're going to want to focus on what records were reviewed. Did this expert review everything? Are there key documents that this expert failed to list that were reviewed? Anything missing? Did they read all the transcripts? Did they read all the medical records? Do they cite to everything? Perhaps they miss some key documents. So you're going to want to look at what they did as far as the record review. That's always listed. Was an inspection performed? Maybe it's a car expert, an engineer, a motoring engineer, maybe an accident reconstructionist. You're going to know, did they perform an inspection? When did they do it? Did they actually go in person? Did they just look at photographs? There's a lot of case law out there, and ultimately you're going to build up this case to maybe get the expert precluded from even testifying if you can establish that all he or she did was look at photos, and that's not sufficient under the law to opine on the issues this expert opined. So look through the conclusions, the opinions, see what the opinions are, because experts are going to be locked into the opinions contained in the disclosure or the report. If the opinion's not in there, then they can't bring that up at trial. So zero in on the language of the opinions, of their conclusions. Does it hurt you? Maybe it doesn't. Maybe they go through this whole summary and in their final opinion, it doesn't really say anything that you care about. That doesn't hurt your case. What if they opine on something that's out of their wheelhouse? Maybe you have an engineer who starts talking about medical causation. Well, an engineer is not a medical doctor unless they went to medical school. So look and see if maybe their opinions are out of their area of expertise, but really take time to read through, see if anything helps you. Sometimes they'll put something in there that'll, think of a typical doctor doing an independent medical evaluation for an adversary. Maybe they put in a thing on causation. Maybe they say that the injuries are permanent. Maybe they give a strong report that helps you, and then you just want to spend the time in the deposition preparing to bolster that because it's helpful to you. Maybe they failed to say something. I had a case that I've talked about in this CLE where our client was evaluated by an orthopedist, and you'll see I attached that in the materials. I've attached the materials today. I have 2 transcripts from the same case. Our client was rear-ended by a tractor trailer and had back injuries. And you'll see there's a deposition. I conducted both of them. One is of an orthopedic surgeon who evaluated my client, and the other is of a vocational person who evaluated my client. And I suggest if you have time to read them, because you'll see what I'm talking about. You'll see how you can use them to help your case. And I noticed in reviewing the orthopedic surgeon's report that was disclosed that he didn't really dispute causation. And so I started asking him, I'm like, I don't see any dispute. Well, that's not my place to talk about that. I'm just looking at limitations. I'm like, okay, but to be clear, you're not disputing that this accident caused his injuries, are you? Well, I'm not here to talk about that. I haven't reviewed everything to determine causation or not. I'm like, so as you sit here today, just to be clear, it's not your opinion that this isn't causally related. We'll talk about how you have to fight the experts sometimes because they're going to be evasive like that, but you can get good stuff. All right. When you're looking at the report, look for references. They're either going to be like a footnote where they cite to an article or a journal or a study or a treatise, or they may attach a list of references on the back of the report. Then get those references and read them all. You'll be surprised. We're going to talk about that in a moment of how that can help you. Because sometimes they reference something to support something they're saying, and then when you actually read the reference, it doesn't say that at all. So you have to look at that. And if they don't have references, then they're just speculating. Are we supposed to take your word for it just because you say you're an expert and you're saying all this stuff? Where's the science behind it? Where's the studies behind it? What's the basis for your opinions here? All right. So you're going to want to look at the references. Now, recently, I questioned a toxicologist, expert for the defense. And the issue in my case was regarding whether or not my client used cannabis, marijuana, and whether or not that had any impact on the case. So one of the things that this toxicologist said is that when you smoke marijuana or cannabis, it's going to increase risk taking. And obviously, he's implying that my client was being risky and that was a cause of the accident. He says that in so many words, and then he footnotes an article, risk taking in cannabis, something like that. So I get the article and I read through it. And it turns out this article was from like 20 years ago. It was 10 people in this study, and they had 10 people sit down in front of a computer. They gave them each a joint. They had them all smoke a specific regimen of how many puffs, how long they hold it, how long they exhale it. And then popped up on the computer screen, they were given $6 on the screen. And then they basically had to decide, do they want to just play it safe and maybe make, a small percentage increase on it? Or do they want to, that's option A, or do they want to do option B, where they could get greater gains and maybe double their money, but they could also lose their money? And sure enough, the ones that got high from smoking the joint on the computer were more likely than not to choose the risky option. What that had to do with the facts of my case, which was a sporting activity, had nothing to do with that. And so I lock him in on his deposition. That's the sole basis you have for saying this causes risk taking, this study? Yeah. So you have to read these things because half the time the experts don't even read them. They just have the title. Maybe they've used it in another case. So get the references, read the references. Don't be afraid to challenge an expert. That's your job. Don't be intimidated that this person has expertise in an area that you don't. Because you can learn it. You'll learn the information specific to your case. What's the best way to handle a bully? We all know that. You go punch him in the face, right? So that's what you're doing in that boxing match. You're going to get in there, you're going to punch that expert in the face figuratively because you're going to be more prepared. You're going to take it to that expert. Then you want to look at the curriculum vitae. A curriculum vitae is a resume of an expert. And on the curriculum vitae, it'll show if they have board certifications. It'll list their education, any academic appointments, hospital affiliations if they're a physician. It'll list their presentations, publications. So you're going to want to take a good look at the curriculum vitae. Excuse me. You're going to want to see how much of an expert is this person? Is this expert from a college you've never heard of in the Midwest that somehow they got to say this stuff, that hasn't published anything, that hasn't lectured on anything? Or is this expert from an Ivy League school undergrad, an Ivy League graduate school, the PhD in that area, published a lot of studies on that, written a lot of articles? You're going to want to know not all experts have the same qualifications, okay? Getting back to the toxicologist I was talking about, who I questioned recently, he was a toxicologist, but just because you're a toxicologist doesn't mean you're an expert in how cannabis affects people. And when I pressed on this expert and I looked at his CV, he hadn't published anything, not to mention publishing it on the effects of cannabis, hadn't presented anything, no academic appointments. Basically, he said all he knows is from reading other articles, the same articles that I read that don't make sense. So, one of the goals ultimately, when you are questioning an expert, is perhaps to get them precluded. In federal court, it falls under Rule 702 and a case called Daubert you may have heard of. In state court, it's the equivalent of Daubert, it's called Fry. And in essence, experts can only testify if it's a matter outside the general knowledge of a layperson, of a juror. And they have to have a foundation for what they say. They have to have a legitimate basis. They can't just say, I'm a toxicologist and this is what I say and I'm an expert. If it's nonsense and they're speculating, you can get them precluded from coming to trial. In a serious auto accident case, this will often be a situation with a biomechanical engineer. Many of you have seen that, where it's a soft impact, right, between two cars. And you're handling it as the plaintiff, and your client had fusion surgery from being rear-ended. And the defense hires a biomechanical engineer who says, are you kidding me? This was a love tap on the back. There's no way the force was enough to cause these injuries. Well, I tell you what, they can't say that unless they have a medical degree or medical training. There are some biomechanical engineers who have medical training, and they can say that. But if they haven't, biomechanical engineers are engineers. They don't treat medical conditions. They can't opine on causation. And you could make a motion in limine to preclude these biomechanical engineers. So if you see those appear in a case that you're handling, you're going to want to get that information. You're going to want to move to preclude. Sometimes you could do it even just on a report, right? So check out the curriculum vitae. See, is this an active person engaged in the specific area in your case? Is it an engineer who you find out ultimately handles mostly like slip and fall and trip and fall cases, but here they're reconstructing the automobile accident and it turns out they've never done that before? They're not going to do too well. You're either going to get them precluded or make them look really silly in front of a jury. Right?
If you are joining us via podcast, the first attendance verification code is POD 115. That's POD 115.
And during this break, I saw some questions, really good questions. I still have a lot more to go through. I'm going to have to pick up the pace actually a little bit, and we'll address all those questions at 2 o'clock. So please stay with me from 2 to 2:30. That's sort of where the real action happens. Research the expert. And what I mean by that is research the expert every way possible. And I'm going to give you some suggestions. Always, always, always Google the expert. Type in their name, type in the expertise area, see what comes up. I mentioned in a prior case I had where it was a different toxicologist on intoxication in a subway accident case I had. And I Googled the expert during trial because there really wasn't, it was state court, there wasn't a report. And I found out that he got charges brought up against him by the New York State Attorney General and had to give up his lab and go to Florida for like 10 years. And he was flying in from Florida for our case. Boy, did the fireworks kick in when I brought that out during cross-examination. So Google your experts. You may find nothing, you may find a gem. So always do that. Look for prior cases. There are ways you can search on Westlaw and Lexis. I actually find Lexis has a program called Context where you can search experts. And you type in their name and it can give you like briefs, CVs, other places they've testified. So look on the case research, Google them, see what other cases they've been in, see if they've been similar subject matter to yours. Like I said, maybe all they do is trip and falls, and you see that in all the cases, and here they're really out of their wheelhouse with accident reconstruction. C, maybe they've been previously challenged under Daubert or Fry. One of the Academy sponsors, the Expert Institute, can do those searches for you if you work with them, and they can find out. And you want to do this when you're looking to retain your own expert, either as a plaintiff or a defendant. You know, why in the world would you want to bring an expert in when there's so many you can choose from if they've been precluded in a case? It's just, you know, why create trouble for yourself? So take a look. Have they been challenged? Have they been challenged for doing the same exact thing that they're doing in your case? I have a case like that right now with a biomechanical engineer. I spent months preparing for the deposition. I found 7 cases this engineer was previously precluded in, and one for creating a computer model, the same exact thing he's doing in my current case. So you can be certain that in a motion to preclude, I'm going to be highlighting that. Don't kid yourself. If a judge sees that another judge has already precluded this expert for doing the same thing, that's good stuff. It doesn't control, it doesn't mean they're automatically precluded, but it helps. So you're going to want to look in that. Many of us know about the New York Jury Verdict Reporter. It's an ALM product, and you can do an expert search. So you call up, you ask them to do an expert search, give them the expert's name. You'll get emailed to you a packet of all the cases the experts testified in. You'll see if it was for the plaintiff, for the defense. You might see this expert is on the winning side all the time, maybe good expert, or maybe on the losing side. It's information. You'll see if this expert works mostly with plaintiff or defense. When I retain experts, I generally like to use experts that do equal. They do defense and plaintiff. I want a credible expert. If you're on the defense side or insurance side and you keep hiring these same defense experts over and over and over again that are mills, it's not doing you any favors. I've talked about this before. You have to find legitimate experts, because otherwise, just because they're going to come in and say, oh, there's nothing wrong with the plaintiff, and you think that that helps you, ultimately, when you go to trial and they're exposed to be, 99% defense, and they review 1,000 cases a year for the last 30 years for the defense, and they never find anything wrong, that's not going to be credible to a jury. They're going to roll their eyes. Get credible experts. And you want to look, you want to see if the expert you're going to be questioning, maybe they're a legitimate expert. Maybe they're brought in, maybe your client suffered an eye injury in the catastrophic automobile accident and their vision is almost blind. And the expert that the defense hires is a real top-notch eye surgeon who maybe doesn't testify all the time. If that's my case, I'm gonna put a lot more credibility and be more concerned about that expert and ramp up my level of preparation, as opposed to someone that I find is, was the bottom of their class at a foreign medical school who all they do is defense work and they don't have any specialized knowledge in the eye. Okay. Look at social media. I found stuff on social media because the search engines are so tied in now with Facebook and Instagram. If you search for an expert on social media, you'd be amazed at some of the stuff you come up with. You just don't know, and it can be helpful. Maybe it's not, but look, get prior reports, prior transcripts. You can do this on Lexis. I think there's a way on Westlaw. If you go on the jury verdict reporter and you see this experts testified in prior cases adverse to your side. So if you're a defense lawyer and you see this experts always done work for the plaintiffs, and you can call up one of the defense lawyers in the cases you found in the jury verdict reporter. Say, hey, do you have a report? I want to see if he said the same thing. Do you have a transcript? And on the plaintiff side, we do that all the time. It's not uncommon that I'll get, 5, 6, 7 transcripts on an expert, and I will review them all. I'll read them all. I'll digest them all to find out if this witness has said something that actually contradicts what is said in the report, or maybe it's helpful if they've given prior testimony about something to my case. So you want to get as much information. That's why you have to start early. I find many lawyers are really happy to help each other out with transcripts. I do it all the time. People reach out to me. I reach out to others. I have my colleagues that are really good about keeping the databases of transcripts that I reach out to. We all should help each other. That's what we do. So look for that, all right? Make sure you demand the expert's file on the case. You are allowed to do this. In federal court, you serve a notice. If it's state court, you can do a subpoena, but you are entitled to all non-privileged information in that expert's file, and you want to get it and fight for it before the deposition. You want to see what's in there. You may find some gems in there. You want to see, is this person an expert who came in? Did they take measurements at their inspection? Are there photos in the file? Are there notes that they wrote things on? You want to look for all this. Don't just assume you can't get it. You can get it as long as it's not privileged. So push for all of that. Invoices are a bounty of information. They can be, at least. Many times these experts will itemize their invoices to the lawyers, and you're allowed to get these invoices. It'll say, inspection at site, 0.5, and what their hourly charge is. And I love that. I say, oh, you only spent a half an hour investigating this serious case? Did you take measurements at this inspection? When did you go? Where are your notes? Where are the photographs of your measurements? How do we know that what you measured is actually accurate? Did you photograph the tape? Did you draw a diagram while you were there? So get those. Get a tutor. And what I mean by that, and it's also one of the things I love about preparing for expert depositions and just preparing the cases that we work on where we have various experts on liability and damages. Have a tutorial. Before I engage with an expert on a serious catastrophic case, before I question that expert, I reach out to my own expert, because usually if they have one, you're going to have one. And if they don't, you should get one, unless you are super, super knowledgeable. My good friend John Bonina, past president, he probably doesn't need to speak to a doctor before he goes and questions a physician on any case, because he's practically a doctor himself, so he knows what he's asking. But if you don't have that knowledge because you haven't practiced medical malpractice for your entire life, then get the medical specialist, retain an orthopedic specialist, retain a physiatrist, retain an anesthesiologist. Give them your adverse expert's report. The person you're going to question, give them the report, give them the file. Say, let's set up a Zoom for an hour, pay them for their time, and they'll sit through and they'll be like, yeah, see where he says or she says this? That's not true, and I can show you how it's not true. Make sure to ask them how they got to this, to make that opinion, and ask them if they did this measurement or this test. It's amazing how you can learn so much, and most of us, we're always learning. That's what we do as trial attorneys. That's what the good trial attorneys do. They're open to learning new information. So whether it's a subway accident case where you need to have a train operator explain to you how you work and start and do everything, right, Celeste? Or if it's a construction accident case where someone needs to teach you how to work the lift and where the emergency stop buttons are and how to do it and the user manual, or a catastrophic injury case where you're working with an economist to prepare for their economist, or a vocational expert, or a life care planner. I always set time to review my case with my experts. I always ask them, hey, can you give me some questions? Don't go crazy. Just spend an hour looking through and just type up a list of questions of things that you think I should ask. And then they're always happy to do it. I find experts like putting on their lawyer hat, and if they're engaged in the process, they enjoy that. That's part of why they are experts. And so I'll incorporate those questions into my outline. And then you create your outline. That's going to be your foundation, is your outline. That is your bedrock. I used to do all my outlines for everything. For trial, I still pretty much use my yellow pads. But for depositions, especially expert depositions, especially with doing them by Zoom now, my method that I found really, really helpful is I do an outline. I have a Word document up and I'll create headings on the areas that I want to get into, what my goals are. And then I'll do bullet points. I'll do specific questions. If there's a real key thing, I may type it out. Otherwise, just sort of topics and subject headings. If there's an exhibit that I want to show to the expert, let's say their report or their curriculum vitae, I want to go over with them. I'll pre-mark everything, exhibit 1, exhibit 2. Then I'll create a folder on my computer. So let's say the report is a 10-page PDF. I'll do a subfile on my computer that says deposition exhibits for expert Smith, toxicologist. And then I'll put exhibit 1, I'll label it exhibit 1, I'll save a copy of the report in there. I'll label exhibit 2, the curriculum vitae, I'll put that in there. Same thing with references. I'll label those, put them in that folder. Same thing with photographs, any evidence, anything that you want to discuss with them. Then in my outline that I type, I'll say, go to exhibit 1, report, and I put it in red. I change the color. All my exhibits I always do in red. So it's color coordinated. And in some cases, I did a deposition of an expert where I had like 35 exhibits. I didn't get through all of them, but that's okay. You could still pre-mark them. And when it's there and you have your computer set up, it's very smooth. You're screen sharing. Let's take a look at your report. I've highlighted this paragraph on page 3 of what I've marked as Plaintiff's Exhibit 1. And what did you mean by that? And do you have a reference for that? So it's being organized. And when you prepare properly and you organize your exhibits and you organize the sections of your questions, you can move them around later on, but the outline becomes a living, breathing document. You may think of something early in the morning or late at night, like I do, and get up and just go to your computer and add something, type it in, change stuff, add stuff, bold, enlarge. I find that that's really helpful. And then, you organize it based on what your goals are. What do you want to get out of this expert? If you've read the report and you think that maybe it's an independent medical exam, it's an orthopedic surgeon, and there's stuff that helps you, your goal may not be, you don't want to preclude this expert. You want this expert to help you. So you can have a whole section building this expert up, maybe. Oh, and you've done this and you've done that. So you really know what you're looking at when you look at MRIs. This is in your wheelhouse, right, Dr. So-and-so? Yeah, it is. And you don't dispute the finding on this MRI, do you? No, I don't. And you certainly didn't give that opinion, right? Right, because it makes sense. Before the accident, there was nothing there. After the accident, it was there. So it's connected, right? So your goal may be to bolster, to get concessions, to get things that are going to help and support your case. I did that once with a vocational expert where I got them to concede that, my client has a 50% income impairment. And I just walked them down the path of that. And it was great. Maybe you think that this expert, based on your research, is just, I don't want to use a derogatory term, but let's just say a regular expert who's always around, who says anything, who's been precluded a lot. Maybe you just want to expose that expert for being that type of expert. Expert for hire will say anything without any basis. And you want to get him precluded or her precluded. Then that should be a big section. Where I talked about an expert that was precluded 7 times. I came right out of the box in my outline. You ever been precluded from testifying in a case? Well, I think I was limited once, but that's all I remember. Well, how about this case? Do you remember that one? No, I don't remember it. Well, it was in this state, and it was this judge, and this was the subject matter. You remember that? It doesn't sound familiar. And you were precluded by the judge in that case for saying blah, blah, blah. And then you go right through it. So just get organized, have your exhibits ready, have your subject headings. Subject headings should always be their qualifications and their background. Go through that. Mark it as an exhibit. Ask them, is your curriculum vitae up to date? Do you need to add anything, modify anything? Ask them about the information they relied upon. Ask them all the questions that you're curious about. Don't be shy about asking open questions. At trial, you want to cross-examine with leading tight questions. But in depositions, you want to give them free rein to say what they're going to say. And then that's it. You're locking them in. That's one of the goals of an expert deposition. Look, it's rare that you're ever going to leave a deposition where you've questioned an expert and say, oh, I hit a home run. I nailed this expert. They confessed to everything. I got everything I wanted. But if you are successful, if you lock that expert in, for example, is this the only study that you rely upon that cannabis causes risk taking? Well, I'm sure there's others. Well, I'm not asking about others. I'm asking about, you said you've read these studies. Is this the only one you know about? Well, there may be others. All right, tell me another one. I don't know as I sit here today. Fair to say then, sir, that the only study you relied upon to form the opinions in your report that he was taking risks is this study you cite, right? And then he says yes, and then you get into the study and show how it means nothing. That way they can't show up at trial later on with a different study. It doesn't work that way. You can preclude them from bringing something in that it was never disclosed and wasn't part of his report and wasn't part of his opinion, and then you make them look silly. After I grilled you at the deposition, you went back and did some more homework, right? Is that what you did? So find out the basis. You're going to want to go through your outline, subject headings, basis of opinions, challenge them on the references. You're going to want to do all of that in your outline. Now let's talk a little bit about preparing your expert, and then I'll get into conducting the deposition. We have about 15 minutes left before the Q&A. So let's say it's your expert that's going to be questioned. You've retained the expert. It's your biomechanical engineer. You're the defense lawyer. You've retained this expert to say that the impact wasn't significant enough to create the force necessary for these types of injuries. Maybe your biomechanical engineer has a medical degree, maybe not. But you need to prepare your expert the same way that you need to prepare all of your witnesses when they're going to be deposed in any case. Especially an expert needs to be prepared. Don't let them say, I got it. I get questioned all the time. I'm good to go. Say, I appreciate that. I'm sure you're going to be great. I'm very excited that you're involved in this case. But humor me. There's some things I just want to go over with you just to make sure we're on the same page. Okay? They're like, sure, go ahead. What do you got? I always ask the expert, has anything come up ever at trial, at a deposition that didn't look too good for you? For example, maybe you said something at a deposition once that they keep coming back and throwing in your face. Maybe you failed a bar exam or a board exam. Maybe you got something happened. Anything, I need to know now because I don't want to be surprised. As long as you tell me, it's all good, and then we can just prepare for how to handle it. Because the worst thing is if you're sitting there and your witness is being questioned and you're caught by surprise. Have you ever been precluded? What were the circumstances of that? You're a biomechanical engineer. Do you have any medical training? Have you been pushed hard at depositions about your lack of medical training? How do you handle that? How do you handle a question that asks how you can opine on whether or not the accident caused this person's injuries? So you want to spend time really working with your expert. You want to go over the types of questions you anticipate. You want to tell them how to navigate questions, especially if there's tough stuff or areas they're not as strong. So it's really important that you do that. For example, tell them that, sorry, I'm switching gears on you. I'm looking at my outline. You've heard me talk about the hand, okay? And what I do is I have a little trick that I use when one of my clients or one of my experts is being questioned and I want to object to the question that's being asked. And I'll put up the hand. And what I do is I say to them, if you see my hand come up on the Zoom or if we're next to each other in person in front of you, stop talking. It means I want to make an objection and then wait until you get direction from me. Either answer the question, don't answer it, whatever it is. So tell them about how you like to handle yourself in a deposition. I usually say to an expert, listen, it's pretty much fair game. They can grill you. You're a paid expert. I'm going to let them ask their questions. I don't like to interfere. It just drags it out. But if there's something that I have an issue with, I'm going to put up my hand and you just buckle down. Okay? Don't say anything until I give you further direction. So have that meeting well in advance. Don't do it the day of. I hate when people prepare for anything on the morning of or the day of. Schedule a time. Work with your expert and prepare them. So you're either preparing yourself to question the expert or you're preparing the expert to be questioned. All right. Now, conducting the deposition. Let's talk about that for about 10 minutes. All right, take a sip of some tea. So when you're conducting the deposition, it's important to keep your cool. It's important not to engage with your adversary and have long speaking objections. You need to stay focused on your mission. Your mission is to get the answers to your questions. And you've spent a lot of time preparing. You're ready. You know the material. And you need to work hard because you're going to have an evasive, likely an evasive witness to make sure they answer your question. Now, before the deposition starts, you may be asked if it's the usual steps. We've all heard that. Usual steps, counsel? Yeah, usual steps. Show of hands, how many have actually read the usual steps, right? I see you. I know who does and who doesn't. I bet a lot of you do and a lot of you don't. There are different steps in federal court and state court. I've included those in the materials as well from some depositions. In essence, all the usual steps are the same, and there's really two main takeaways from them. The first is that all objections are preserved for trial, all right? All of them. You don't have to object every single time. The only type of question and objection that is not preserved is an objection to form. God knows what that means. We know what it means. You can't ask two questions in one. You can't say, where were you and what were you wearing, right? It's either where were you or what were you wearing. That's improper form. But that's the only type of objection you can make is to form. Everything else is preserved, all right? Now, except for privilege, obviously, if there's a privilege, if there's an attorney, expert work product privilege, if there's a marital privilege, attorney-client privilege, so you can always assert an objection on privilege. But other than that, it's fair game, folks. And it's rare, even with the most seasoned attorneys, that they'll just sit there and let you question. I mean, I had a case once where I was questioning an expert, and the defense lawyer objected to every one of my questions. I'd ask a question. Objection, speculative, argumentative. He'd throw in like 5 different things. Objection, this, that. And I turn to him, I'm like, listen, we have the usual steps. Your objections are preserved. I will put on the record right now, and I'm doing it. You are not waiving any objections. You don't need to object to every one of my questions, okay? I'm allowing you to preserve every objection to every question I have at trial, all right? No, I still want to object. And because sometimes they'll do that to try and throw you off your game. And I don't care for that at all. I don't care for that behavior. If there's something appropriate to object to, do it. If not, get into it. And what'll happen is that you'll be asking a question and an expert won't answer it. And I'm going to give you an example. All right. Let's say you have an expert biomechanical engineer who wants to say that the car was going 35 miles an hour at impact, and based on that speed, the forces wouldn't be enough to cause the injury. But there's no evidence in the file that the car was going 35 miles an hour. It's not, a witness hasn't said it, the driver didn't say it, there's no event data recorder. So you want to highlight that this witness is coming up with nonsense. They're speculating about the speed, and they can't speculate when it comes to scientific calculations. So you'll ask the question, and Dr. So-and-so, isn't it true that you don't know what speed the car was going at the time of impact? The answer will be, well, actually, I do. It's my opinion that based on this and based on that, they were going 35 miles an hour. I'll say, well, I'm not asking your opinion. I understand you have opinions in this case. I'm asking you if there's any factual data that you are relying upon that says, like you do in your report, that the vehicle was going 35 miles an hour. Well, yeah, it's easy to tell that because you look at the brakes, the skid marks and the swerving, and and then they'll just go off on tangents, and then you don't want to move on from that. You want to get the answer that there's nothing in the file that says 35 miles an hour. And a lot of times what a lot of my adversaries like to do is they say, asked and answered. Smiley, you've asked that 10 times. You may not like the answer, but he's answered it. And I say, I asked it 10 times. I'm going to keep asking it because they're not answering my question. And if you're not going to let them answer the question, we're going to get the judge on the line. So you need to stay focused, and you don't want to get taken off track. You have your mission, and sometimes they may say something or give a certain answer that pulls you in a different direction. It's all right to follow. You need to listen to the witness when they give an answer, because sometimes they say something good that you weren't expecting. You can't have blinders on to your outline. So it's all right to go off the trail and follow that answer and see where you go, but then come back. Come back. That's why an outline is important. Come back to your outline and get back on track. So that's really important when you're questioning. It takes a lot of composure, especially if you have multiple defendants. Objection, objection, you can't do this. And you just have to keep your head to the grindstone, focus on getting the answers to the questions. Don't engage in argument. You're paying for that. We all pay for these transcripts, a lot of money per page. And if you spend, 3 pages fighting with your adversary when you're not going to agree, you're just going around and around and hearing yourself speak, you're racking up $20, $30, $40, $50 in bills from generating pages of argument. It's the worst. What you say is, counsel, appreciate you not making speaking objections. You've made your objection. I'm going to move on. So keep things short and tight. It's not easy to do. It takes a little practice. It takes a little confidence, especially if you're a younger lawyer. But I remember as a young lawyer being thrown into a deposition, it was a medical malpractice case. I had like 4 different prominent med mal defense lawyers, and I was questioning one of the doctors, and they were throwing objections to every question and giving me a hard time. And, that's how you learn. That's how you learn. Stay on point. Stay on point. Get your question answered. Okay. It's really important. That's the only thing that you have to worry about. You have this great outline, you're prepared, but, I didn't get to that. Get to it. Get to what you need to. And bring the judge's chamber's phone number with you. Chambers in courtroom. Always, 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 whether you're on the plaintiff side or defense side. And don't be afraid to use it. Okay? You don't need to get into arguments with your adversary. If they're not going to let the witness answer the question, or if you think that a lawyer is harassing your client and you want no more of it, then say, let's get the judge on the line, and don't bluff. Call the judge. They'll make a record, they'll make a ruling, and you'll continue on. Sometimes you may want to save. You can ask the court reporter to mark certain questions for a ruling, wait for a break, and then you could say to your adversary, listen, I'm going to call the judge now. Do you want to reconsider any of your positions here on blocking before we get the judge on the line? Sometimes they do, sometimes they don't. So don't be afraid to call the judge. Have the judge's number. State court, it's kind of tricky, but sometimes you'll get a law secretary who will make a ruling. Federal court, I usually get a judge on the line. They're usually happy to do it and resolve it. You want to box the witness in. You want to lock them in to their answer. We spoke of this earlier. That's when you'll know you've done a good job. You've gotten out everything they've relied upon. You've gotten out all of their opinions. So there's no surprises, okay? You want to avoid surprises at trial. And ultimately, if you've gotten the answers to all the questions that you wanted to ask, you've locked that witness into their answers, so there's not going to be any surprises at trial, you've done a great job. And in being prepared, asking the right questions, having the knowledge of what the references say and the subject matter, knowing what you're doing, that's going to earn you a lot of respect from your adversary. I'm always honored when at the end of a deposition, one of my adversaries says, well, you did a pretty good job there. You knew what you were talking about. I'm like, yeah, well, I prepare a lot. Because then your adversary knows maybe you made their witness look bad. They know this witness isn't going to look as good as their report does when the witness has to be called at the time of trial. Then it gives you that leverage when you're negotiating the case. You can say, yeah, you were talking all about how you were going to say this and your expert was going to say that. I don't think they're going to do too well in front of a jury after that deposition, and I sized that witness up. So you're showing your adversary your level of preparation. You're showing how this witness is going to come out at the time of trial in front of a jury, and that you're the prepared type. And if they don't want to resolve the case now or deal with it, this is what they can expect at the time of trial. So there's that element of it also. You always want to be on your game when you're in one of these adversarial situations questioning an important witness.
If you are joining us via podcast, the second attendance verification code is POD 507. That's POD 507.
Let's do it. Comments, questions. This is a time where there's a little back and forth that we can really talk about issues that you've got going on. Nothing is off the table. You can ask anything you want. I'm going to start going through a few of them. Sharon asks, where do we begin to learn a history of cases where the expert testified? So I think I touched on that. You're going to do a Google search, Westlaw, Lexis, New York Jury Verdict Reporter, and then from there you go and get transcripts. So those are really the main areas. New York Jury Verdict Reporter is really, really helpful. And you can get that. I think Westlaw, Lexis has both of those. Also, Lexis has the context part. And dig away, keep digging. Because sometimes you get one case and it refers to that witness being in another case. And I love that part. I love the sort of detective work and digging things up. It's really helpful. Call the lawyers up that you see involved in the case that are on your side. See if they can share with you. Maybe they did their homework and they have other transcripts, other things that they can share with you. Okay. David, hello. You are asking, how would I address the cross of an expert who lists on his CV a research article from 30 years ago, listing himself as the first named author, as the only article on his CV? And then you get the actual article itself, he's not listed. Plus, the authors all deny knowing who he is. I've been told it was inadmissible because of the prohibition about admission of extrinsic evidence on cross of ancillary matters. That is a great question. You're going to get that in. I mean, if he's listed, his curriculum vitae, his credentials are an issue. Any expert's qualifications are a legitimate issue to inquire into. And so you put him on the stand, you say, this is your CV, it's accurate, you've read it. I see there's only one article you published 30 years ago. You recall this? You were involved in this? I'd lay the whole foundation. Tell us about it. This involved this involved that. I have it here. And the interesting thing is, sir, I don't see your name anywhere on it. I see all these other people. I have affidavits from them that you weren't even involved in this. Can you explain that? And then, I would work it out somehow like that. You can definitely work that out somehow. Same way any witness's credibility is always fair game. Bias, credibility. This goes to, he's trying to bolster his qualifications. Say that's the only thing you've ever published. And that was 30 years ago and your name's not even on it. So you haven't published anything else, but you're an expert on this? Okay, Michael, in federal courts, the expert's report must be substantiated with medical principles. You had an expert's report stricken and the expert precluded. Good job under Daubert and Federal Rule 702. They're unable to produce a list of cases. So be cautious, defendants and plaintiffs. Retain a good expert. Have a solidly written report in federal practice. Great advice, Michael. And absolutely, in federal court, when you disclose your expert, that's under Rule 26A2. And you have to give a report. You have to give a list of testimony at deposition or trial in the last 4 years. You have to give the curriculum vitae, and you have to give the fee schedule. So those all have to be part of the disclosure. So picture if you're in state court, like a 3101 disclosure, you're gonna have Exhibit A report, Exhibit B curriculum vitae, Exhibit C fee schedule, Exhibit D list of testimony, and so on and so forth. So get a good expert. You're spending money, make them comply with your questions, screen them. There's plenty of experts to go around out there. You want one that's going to be credible. You just do. All right, John is saying all physicians can comment on causation or lack of causation, even without biomechanical engineering training, correct? Yes, it's interesting. I'm working on a motion to preclude a biomechanical engineer right now. And this particular one doesn't have any medical training and opines on causing the plaintiff's injury. And if you research the case law, at least the federal case law in the Second Circuit, the Eastern District, Northern District, Southern District, and many of the state courts around, the body of case law generally, and it's different in some jurisdictions. Some jurisdictions will let a biomechanical engineer talk about medicine. But I came across a case just the other day, and they said that they were trying to justify the biomechanical engineer talking about injuries. And in that, the argument of the litigant was, listen, a medical doctor doesn't have biomechanical engineer expertise, so they can't opine. And I'm a biomechanical engineer, so I'm the one who's appropriate to opine. And the court shut that down. They said, listen, medical doctors are qualified. Indeed, I think this is a quote, indeed uniquely qualified, close quote, to opine on causation of a medical injury. So that is absolutely in the wheelhouse of a medical expert. And if you are on a plaintiff or defense side and causation is an issue, you must get a medical doctor to opine on the causation. You're taking a big risk if you're not, and all you're doing is relying on a biomechanical engineer who is not also a physician. There are some out there that have degrees in both, but medical doctors are the ones to opine on causation of a medical injury, plain and simple. Thank you, Michael, for your nice comments. Celeste, thank you for participating as always. And okay, Dr. Cordero, how are you? we're gonna need to move our one-on-one tomorrow. I'll reach out to you separately by email. Something came up for me, but by the way, for those of you who don't know already, I've been doing one-on-ones with everyone who wants to. Just go to thementoresq.com. It'll pop right up to schedule. We do 30-minute Zooms, no cost. We talk about case values, experts, referrals, cars, anything. It's just a half hour to get to know each other and talk shop. So please feel free to take me up on it. I've really been enjoying meeting with all of you. Can you move the court to be the one who appoints an expert acceptable to both parties so that the expert has no bias towards either side? Otherwise, can you provide the opposing party with a list of 10 experts and ask for that party to provide a similar list to you so that both of you can have an expert acceptable to both parties? That's really interesting. So the concept, if I understand your question correctly, is, listen, to take away the bias issue, let's both sides agree on one expert to determine something. And we'll agree on that expert and live by what the expert says. You certainly can do that. I can only recall once that I did something like that. And that was in one of the cases that I've talked about in this series, the Matthew Ferber case, where the guide rail pierced through, it broke off, pierced through the car and amputated his legs traumatically. We agreed it was a case against the state. We all, even though we had our own metallurgists, they're experts in metals and properties of metals and all of that, we wanted to have the guardrail inspected. Both experts agreed that they wanted to send a piece of the guardrail to a lab to have the properties of it evaluated. So we agreed on which lab that we would all use. And so technically that's an expert. They're giving an expert opinion on the properties of the guardrail. And we agreed on who to use. We found in that situation, it's really objective. Both said it was a credible lab, and we went ahead and did that. So in theory, you can. In practical application, you're not going to want to share an expert. You're going to want to have your own to look at it from your perspective and to be an advocate for your case. That you can have an advocate for your case and have them being calling it as it is, but they can still be an advocate for you. You can't do that if you're sharing. So that's my thoughts on that. Carol, have I seen the recent second department case, Canciani versus Stop and Shop? Expert was precluded for not including the documents that he reviewed. Interesting. I have not seen that case, but that's great news. You know, that's one of the reasons you want to get the file, you want to get the disclosure, you want to get the reports, because if they don't have anything, I mean, I've done depositions of experts where they show up and they don't have a file. Oh, I don't keep the medical records. I don't keep this. I just have my notes. Like, you don't have a file? No. I mean, it's just, it looks really bad, not only a deposition, but when they come up to the stand without a piece of paper in front of a jury. Jim, do I prefer treating physician or separate doctor to be an expert on damages? Great question. I prefer treating physician if the treating physician is well-credentialed and willing to work with us. And it's primarily the main physician doing the treatment. So for example, an orthopedic injury and a catastrophic injury case, let's say it's the surgeon, the orthopedic surgeon that did the spinal fusion, that's treated the client the whole way through from beginning to end, and that surgeon's well-credentialed, well-qualified, and happy to testify. I would love to use that treating physician as my expert. But I have another case where there's been multiple treating doctors, lots of surgeries, and they're not all easily accessible. They're in different states. And in that situation, I'm much happier getting my own well-credentialed medical expert to pull all the records together, review them all, summarize the treatment, evaluate my client, and then it's just that one expert I need to deal with at trial. So depending on the situation, it's worked out great both ways. If you get a great treating, go for it. If not, then get your own on board. And as an FYI, if anybody has cases where their clients were treated by orthopedists from Hospital for Special Surgery, I think it's still the case that like they do not testify. They're great doctors. They will treat your clients, but they will not testify. So that should be a red flag. If your client comes in and they had surgery there, you want to right off the bat start looking for your own doctor to be available to be your expert. Adam, what's up, my friend? Long time classmate from Brooklyn Law School days. Timing wise, in state court, when do you recommend making the motion to preclude a defendant's biomechanical expert in a motor vehicle accident? I recommend doing it as soon as you're ready. That's going to move the dial on getting your case resolved. because they're going to sit back and they'll be like, oh, we've got a biomechanical engineer who's going to say this accident didn't even cause the plaintiff's injuries. We're ready to rock and roll. We'll call her to the stand, and but you throw that motion out there, and then you're going to say, yeah, I know you're relying on that, but I think your expert's going to be precluded. Where are you going to be then? I'm willing to talk now while the motions are pending. So get it out as soon as you're ready. And everybody needs to check the judge's rules, because some judges will have timing on submitting and limine motions and motions to preclude. So just check on when you can do that. But otherwise, you can go for it. Celeste is saying, in federal court, you usually have a time limit on the expert deposition. How do you handle when the expert and lawyer are burning up your time with delay tactics? Great question. In a recent deposition I had of a biomechanical engineer, I'd questioned this one before, the same exact expert. And I knew he doesn't give straight answers. And I knew he's difficult. And he wrote like a 65-page report where he opined on everything. And I spent a lot of time preparing. And I knew there was no way I was going to get it done. You're limited to 7 hours in federal court. So I asked my adversary to agree to give me 2 extra hours, 9 hours. And they agreed, and I got it done. If you don't get that agreement, you're limited to 7 hours or even more, and they're burning up the time, then I would make a statement on the record, and I'd say, listen, I'm limited. We're getting a lot of extrinsic objections, lengthy delays, and I'd ask that you please try and do better. Otherwise, we're going to have to, get the judge on the line. The other thing I always do in federal court when you're limited to time is I ask the court reporter to note the times of all of the breaks, so that it's not just the day of the deposition. You start at 10, you go to 5. That's not 8, 9 hours. You actually, the minute it starts at 10:11, you write 10:11. You take a break at 12:05 to 12:15. That's an extra 10 minutes. So you'd be surprised if you're doing a 7-hour deposition and you're taking 10-minute breaks every hour. There's your extra hour and change. So I always try and do that as well. Robert's asking, how do I deal with the CSI effect on jurors? I'm not sure what you mean. I know the show CSI and how they like to see in the visuals and all of that, but I don't know specifically what you're asking about. Whether they think that the expert, is always right because they get into all this mumbo jumbo. That's part of your job of trying to get them precluded. You don't want them to get into the mumbo jumbo because that's going to confuse a jury. They're talking all this nonsense. You want to show it for what it is before they get to a jury. Carol's asking, if you want to report, do I ask the expert directly or go through the attorney? So if it's an adverse report, you can't reach out to the expert directly. You can ask the attorney. But again, if it's state court, they're not obligated to give you a report in New York State. So it depends on the jurisdiction and the law as far as your demand for a report. All right, John, since it's not the norm, when should you consider deposing experts in state court? Good question. I think if an expert is disclosed in a serious case and is really coming out of left field with a lot of things, then you make an application to the judge saying, listen, I need to vet this in advance. It's not fair to us to have to deal with this at the time of trial. If you really feel that there's items there, generally the law is against you. You have to deal with it at trial when it comes up. The other thing is by making a motion to preclude in New York State under Fry, then they may set a hearing, in which case you're sort of doing a deposition, but you're doing a cross-examination prior to trial without a jury in front of the judge, and that's sort of your bite at the apple. So that's the other way to do it. Opinion and experience with expert referral services, William is asking me. I've worked with a lot of expert referral services, and some of them are excellent. If you want to save money, you try and do it through word of mouth and your own research. But most referral services will get you a no-cost meeting by phone or Zoom with a potential expert. They'll get you CVs. They can narrow it down and find someone for your specific purpose. So, for example, if you need a radiologist to look at some films, that's probably not that hard to find. You may not need an expert service. But I had a case once where our client was a stunt woman, and she was killed during the course of a movie. I think it was Deadspin back in the day. And so we got involved in that case, and we needed a stunt expert. I don't know any stunt men. So we used the service, and they located someone top notch who was involved in major blockbuster movies as a stunt coordinator. So depending on what you need, they'll all work with you and send you curriculum vitae, and you usually only have to pay if you retain them. So I would try using your connections, word of mouth research. And if you can't find someone or you need someone's in a specialty area, then go for it. We have sponsors that do experts. The Expert Institute's one of the Academy's sponsors. We've used them a lot. They're great. They found us that stuntman expert. So I would look at that. Okay. Nicholas, do you refer to authoritative medical engineer text in your deposition of an expert? Sure. So for those who don't know what Nicholas is asking about, a properly trained expert will say nothing is authoritative, because then you throw it back at them at trial. If they cite to something, they say it's authoritative. This textbook on toxicology is authoritative. I did that with the toxicologist. I said, this textbook on toxicology you cite in your report, you would agree that that's an authority in the field of toxicology. Oh yeah, it is. It's on everyone's bookshelves in this. We all use it. I said, great. And that's, you actually use it in this case. Yeah. I said, well, do you remember this section? And I read him stuff that was really helpful to my case. So I do that. If you can get someone to acknowledge something's authoritative, that's great, because then you can throw it back in their face if there's something in that document or treatise or text that helps you. Have you court reporters that do not charge the per page cost for the computer generated attached digestive terms? Good question. I don't know. I don't have an answer to that, Kevin. I'd have to check into it. I don't know if they charge for those. I have to ask my staff to check. Maybe they shouldn't be and they are, maybe they're not. I just don't know the answer. Michael's asking, if deposition conduct of adverse lawyer is really bad, do you prefer to call the judge or make a motion? I like to call the judge. And then you know, if you can get the judge, great. Sometimes the judge will say put it in papers, but then you put you know, you submit the transcript, and there's good case law out there on being obstructive. And if you can show that they objected, you know, 100 times, you know, they can get sanctioned for that. So I would do it both ways. I'd get the judge on the phone. If you can't, then you make a motion. And I don't think you have to preserve it. I think you have a right to appeal for whatever purpose you want. But usually the remedy for an adversary being difficult is sanctions and getting another deposition if they've used up all your time. Val, question about the NYPD Collision Investigation Unit for fatal accidents. Okay, I've dealt with that a bit. After waiting 6 months, I finally got the 2-page report, which is a verbatim cut and paste of the police report narrative. No witness statements, no 911 transcripts, no photos. I'm gonna have to subpoena these things additionally. Yeah, I mean, it's tough. Whenever there's a fatality in New York, they have their special collision unit, their AIS, Accident Investigation Service unit. They go in and they generally do a big workup, photographs, witness statements. It's usually not just a regular MV-104 you're used to seeing. And it does take a really long time. 6 months isn't that long, believe it or not. We've waited a lot longer. It could be that they just haven't completed everything. So you want to ask them. I would call them up and say, is this everything? If not, then get a so ordered subpoena for it. And make sure you do a FOIL request, an official FOIL request. I think you can do that online. Make sure you get everything. Larry, in New York State, can I demand the expert invoice prior to trial as a separate D&I to the expert demand? If I did not include the invoice in the original demand, sure, why not? Demand anything you want. And then if you don't have it before trial, tell the judge you served a notice, you served a subpoena. You can definitely do that. Demand everything from the file. Carol, back to Canciani, if I'm pronouncing that right, the case. It was a summary judgment motion where the meteorologist's report was filed without any of the underlying documents he relied upon. Yeah, again, that's speculation. So that's what's going to happen there. You know, there's good case law that, you know, experts can't speculate. They have to have a basis for their opinions. Anthony, do you think an expert's past with defense firms hits home with juries? Yeah, I do. I certainly do. Many of you know the Amador case I talked about in my first series last year, the one out in Queens. Our client's on a motorcycle and collided. And I think in one of the materials, I had my cross-examination of the defense accident reconstruction expert. And, you know, it was one of these examples where the report read really nicely. We did get a report disclosed prior to trial in state court. And I showed him how to be making opinions without taking any measurements, without doing this, without doing that, charging a ton of money. And then I say, but you claim to be, you're not biased, are you at all? No. And then I show that he worked for the same firm before, that all he does is defense work, that, you know, and yeah, jurors are hip. And what I like to do, we'll talk about trial at the end, but my opening statements, I like to give a heads up to the jury when I know there's things like that. I may say something like, pay attention to the defendant's expert who I think they're going to call at the time of trial. See if you think he's really objective, because I plan on asking questions to show that I don't think he's being straight with you. I don't think any of these witnesses are being straight with you, because that's ultimately what the jury wants. If they feel someone's not being straight with them, then that witness in that side is dead. You have credibility is huge. So I definitely do that. Can a biomechanical testify if they're an engineer, but not a doctor? Again, we've talked about this. They can talk about forces, but the general body of case law is that they cannot say that a specific force did or did not cause a plaintiff's specific injuries. Depending on the court and the case law, some will let them talk about injuries in general. You would expect these type, you wouldn't expect these type to a person, but they can't specifically opine on causation unless they're a medical doctor of a plaintiff's specific injuries. Mark, just want to mention good preparation for expert depositions is not just for trial purpose, but can be critical in a summary judgment motion, mostly from a defense perspective. Thank you, Mark. Absolutely. Absolutely. You know, if you are on the defense side and the plaintiff's expert is talking a lot of nonsense and you move to preclude them or take them down in a deposition, that helps with summary judgment for sure. You always want to do that. Thank you, Roger. Thank you, Suzanne. Alex. Suppose an expert tended to make a certain opinion previously in a different case, but now has taken a 180-degree turn from that opinion. How would you deal with an expert opinion who says that the science has changed since then? That's great. I'd love if that happens. That's one of the reasons you want to go through and find these prior cases, because if they say, for example, that an impact, a motor vehicle rear end impact has to be at least 50 miles an hour to cause any significant trauma to the spine, right? And you have them at that in a prior case. And then they come in your case and they say that your client's case, they were hit at 25 miles an hour. And that was significant enough to cause injury to the spine, right? Then you have two different positions. And then you call them out on it. Say, you lock them in the deposition, say, and I noticed in your report, you say 25, and you say that's sufficient. It doesn't need to be more than that, even at 25. Yes, yes, yes. And you've always held this opinion. They don't know where you're going with it. And they say, but you testified in this case that it was 50 miles an hour. And then if they want to say, well, the science has changed, excuse me, then you say, all right, point me to where the science has changed. How have the forces changed? Do grits boil differently on your stove than anybody else's? My cousin Vinny, it's like, what's your basis for that? That's all this speculation that we try and keep out of the courts from experts. That's why the judge's gatekeeping role is that they can't just say stuff. They have to support it somehow. So if an expert ever comes up with something, your question should always be, what's your basis for that? What are you referring to? And usually they're only out as, well, it's my experience. Say, all right, so it's your experience. So you just want us to take your word for it as opposed to you identifying any studies, articles, textbooks that support what you want us to take your word for. Is that right? Well, yeah, that's how you handle that. John, thank you. I plan to feel better, I hope. Nick, what do you do? The expert claims he or she can't remember how often he testifies. That's a credibility thing. A lot of people who reached out to me, friends and family, I think after Marjorie Taylor Greene was questioned in Congress and she didn't remember anything, conveniently. So that's the same thing. If they don't remember and they don't know, it's your job to show how non-credible that is. So in the case I talked about where I had an expert precluded 7 times and he says, yeah, I don't remember that. No, I don't remember that. Like, you're precluded so much that you don't even remember it. Anybody else that would make a difference. So you just go down the trail. They don't, then you throw it in their face. Oh, you don't remember that? How about this case? And you show it to them. How about this case? How about this one where the judge said, you are speculating, you are assuming, your testimony is inadmissible. Do you remember that? Oh, you don't remember that. Okay, well, let's go on to this case. Any others? So that's the best way to handle that. Will there be a survey for the podcast? Yeah, if anyone listens to my CLEs on my podcast, you can get on Apple Podcasts, Google, Libsyn. So if you listen to one of my podcasts that's a CLE like this, and this will go up there, usually in about a week and a half is the delay from when I do them here. You can get credit from that. Michelle's kind enough to record codes, and then there's a link in the description, and you fill in the codes, and then you'll get emailed credit. Ashley, any experience filing suit against your expert for professional malpractice? I haven't. That would be very unfortunate. That would be unfortunate indeed if your expert screws your case up so badly that you end up having to sue them. Fortunately, I have not, but that goes to show you need to vet your experts. Find someone who's worked with them. Find someone who's put them on the stand before. They've done well in front of a jury. They're good to work with. They're credible. You don't want to be in a situation where your expert does something that really negatively impairs your case. Alex, from some cases I've seen, experts would say they have X thousands of cases over my career. I've read this many MRIs. How often do you use that to impeach an expert, and how effective do you think it is? I like the old school way. Most of you know I grew up in the old school with my dad and his colleagues, and before computers and emails and all that were used. And the old school way is you print out the jury verdict reporter for that witness that's usually, like a foot thick, and you hold it up. Say, I'm looking through all these. You testified here, you testified there. All these cases you've testified in. It's nice to give a visual to a jury. But yeah, I mean, sometimes though it's not a big deal. I mean, a radiologist that's been practicing for 30 or 40 years, maybe they started when they were 30 and now they're 60, still in the prime of working. So 30 years, if they're reviewing, 5 to 10 MRIs a day, it is going to be thousands. And then that's not anything that shocks the senses. So you have to pick and choose what you think is going to be effective. If it's part of their job, yeah. I mean, I've probably questioned thousands of witnesses in my career. It doesn't mean that I'm not credible at what I do. It's just, that's what we do, right? So there's a difference between, someone that's legitimately part of what they do, and that's a bolster to their expertise, as opposed to someone who's an expert witness who's testified, thousands of times. So I'm going to thank you all. I'm going to hand it off to Michael to wrap it up. Come see me on June 1st. We'll talk mediation settlement. That's the good stuff. That's getting resolution. That's what we want to do from both sides. It's important. That's what we always want to do, resolution of these cases. Okay. And thank you all for joining me.